Welcome to QLTS School's video series on the SQE1 assessment. Today we'll look at a sample multiple choice question on torts.
A violinist requires an operation on her wrist. As she is concerned about the appearance of her wrist when playing in public concerts, she asks the doctor about scarring and general risks as a result of the operation. The doctor informs the violinist that there is approximately a 10% risk of significant scarring to the wrist, but fails to inform her about the risk of permanent nerve damage, which is 7%. The violinist undergoes the operation, suffers nerve damage and is unable to play the violin at concert level. Advise the violinist as to her rights against the doctor in this case. A. As the risk is below 10%, this would not be considered to be a material risk. Therefore, the doctor has not fallen below the standard of a reasonably competent doctor because it would be reasonable for other doctors not to disclose that particular risk. B. The doctor did not need to disclose the risk of the permanent nerve damage or the risk of scarring, as both risks were at 10% or less, and it was reasonable that other doctors would have chosen not to disclose those risks. Therefore, the violinist could not bring a claim. C. The doctor should have disclosed the risk of permanent nerve damage, which would be a material risk. Therefore, the doctor has fallen below the standard of a reasonably competent doctor. The violinist could make a claim for her consequent loss of earnings and for the personal injury suffered. D. Although the doctor should have disclosed the risk of permanent nerve damage, which would be a material risk, meaning that the doctor has fallen below the standard of a reasonably competent doctor, the violinist could not make a claim for her consequent loss of earnings. This is because it would be a claim for pure economic loss. E. The doctor should have disclosed the risk of permanent nerve damage, which would be a material risk. Therefore, the doctor has fallen below the standard of a reasonably competent doctor. The violinist could make a claim for the personal injury suffered, but not for the consequent loss of earnings. This is because that would be a claim for pure economic loss. The correct answer is C. All material risks must be explained to a patient. A 7% risk of permanent nerve damage is one which the violinist would want to know about because it would be an important factor for her given her career. The case of Montgomery and Lanarkshire makes clear that the 10% rule now no longer applies, which makes A and B incorrect. By failing to disclose this material risk, the doctor has fallen below the standard of a reasonably competent doctor. The violinist can make a claim for both the personal injury and the consequent loss of earnings, as they are connected to the personal injury and therefore not pure economic loss. This makes C more appropriate advice over answers D and E.